Good evening, everyone. Oh, great. Let's try that again. Good evening, everyone. Good evening. Much better. I'm Troy McKenzie, Dean of NYU School of Law, and it is truly my privilege to welcome everyone here for this year's Kenneth P. Thompson Lecture on Race and Criminal Justice Reform. This is one of the most meaningful events that we host each year. It brings together all of us to examine difficult questions about power, the criminal legal system, and race. Conversations that Ken Thompson confronted throughout his career. We at NYU are proud to honor Ken in this way as the home of this lecture series. Ken, as you all know, was a distinguished alum of this law school, a public servant of rare conviction, and a leader who was able to challenge entrenched assumptions about punishment and prosecution. He was Brooklyn's first black DA, and he rejected the reflexive lock-em-up approach that had defined an earlier era and instead worked to make the system more accurate and more just. He created a nationally recognized conviction review unit that helped to secure the exonerations and also reinforced a basic principle. The pursuit of justice does not end with a conviction. Tonight's program continues his work. We are going to be focusing on the Second Look movement, an effort to create avenues for courts to revisit sentences in light of time, growth, and a more complete understanding of the individual before the court. These policies recognize that punishment should not be static and that the legal system must leave room for reassessment and, where warranted, for change. They also rest on a broader judgment that people are more than the worst acts they have committed. Before we get underway, I want to recognize someone without whom this lecture series would not be possible, LuShawn Thompson, Ken's widow. She is dedicated to preserving Ken's legacy, and her dedication has been extraordinary. Through her leadership and her generosity, she helped to establish the Ken Thompson Social Justice Fund and has ensured that this lecture series will continue. Thank you for all you have done to sustain this work. We are honored to have you with us this evening. Thank you. And before I turn the microphone over to LuShawn, I also want to thank some of the others who have helped to make this possible this evening. This evening's lecture is the product of a partnership between two of our centers, our Zimroth Center on the Administration of Criminal Law and our Center on Race, Inequality, and the Law. And I want to thank those centers as well as their dedicated staffs for bringing this program together. I am very grateful to the executive directors of each center, Courtney Oliva and Patrice Sultan, for their leadership in organizing this conversation, as well as my colleagues Rachel Barco of the Zimroth Center and Professor Vincent Southerland of Krill. I also want to thank Caitlin Dean, Kyla James, and of course Sue Anderson, who each played critical roles in making this evening happen. And finally, thank you to our outstanding speakers this evening. We are fortunate to have an amazing group of speakers who bring both professional expertise and lived experience to this conversation. They will be introduced shortly, but first, let me turn things over to LuShawn.
Good evening, everyone. Oh, boy. Okay. So, good evening, and thank you for attending the 7th annual Ken Thompson Lecture on Race and Criminal Justice Reform. I want to start by thanking Sue Anderson for organizing this event every single year. Thank you very much. Even when I forget, She does it. It happens for some reason. I want to thank our brilliant moderator, Vincent Southerland, along with Judge Gleeson, Kevin Haynes, Jule Hall, and Sara Cohbra. Thank you, and we appreciate your insight and commitment to justice. This conversation feels especially meaningful tonight because we mark the 10th year anniversary of Kenny's passing this year. Can you believe it's 10 years ago that he passed away? As you know, wrongful convictions and giving people a second chance were his life's work. And tonight's focus on second look sentencing is a powerful way to honor his legacy. I'm going to be brief, but before I leave, you know I have to talk about money. Before we leave, I want to highlight the Ken Thompson Fund. This fund allows us to continue hosting events like tonight, supporting meaningful programs, and it keeps Kenny's legacy alive. Your contribution, no matter how big or small, helps to ensure that these conversations continue for years and years to come. Tomorrow you'll receive a link, and if you can give big or small, like I said, give in increments of 10 million, 10,000 and down, all the way to $10. All donations are appreciated, and I thank you so much for all coming out. I don't know what happened today. It was 80 degrees yesterday, and today is 30 degrees. I don't know. But I appreciate everyone for coming out, and have a nice night. Thank you.
Good evening, everyone. Thank you, Troy, for that warm welcome, and Lushawn for those incredibly kind words. And thank you as well for all you've done to support this lecture and carry Ken's legacy forward. I'm especially excited for tonight's conversation because we have a diverse array of perspectives that'll make this an informative and engaging discussion on a topic that is in keeping with Ken Thompson and his legacy. The notion, as Troy mentioned, that we are all more than the things we have been accused of or convicted of and have done, and that the law can be a tool to foster justice, to recognize redemption, and to value rehabilitation, and revisit past dimensions of unfairness and injustice fueled by attitudes of punitive excess that really cloud our judgment when it comes to the criminal legal system. Our goal for this evening is, in addition to honoring Ken Thompson's legacy, is to define Second Look and why it matters, to gain insights into the implementation of Second Look from the perspective of practitioners and beneficiaries, and discuss the ways that all of you can support Second Look efforts wherever you are. I want to remind people, if you haven't already, to sign in to get CLE credits, and I'll remind you to sign out as well so you get CLE credits as well. But before we get underway, let me introduce our panelists and ask them to come up on stage, and we'll begin our conversation. First we have with us the Honorable John Gleeson, who's a former federal prosecutor, former federal judge, former member of the U.S. Sentencing Commission, and now a partner at Debevoise and Plimpton, and the founder of the Holloway Project, which he will tell us all about tonight. He's a national leader in Second Look advocacy who is, among other things, focused on litigating and implementing the law in practice. Kevin Haynes is a client in a landmark Second Look case. He was sentenced to 2.5 decades in prison due to an unjust and unfair sentencing practice in general, and was the beneficiary of Second Look resentencing. 4 decades. I thought you said, you were sentenced, you did 25 years, but you were sentenced to 4 decades. Yes, okay. Let's get, well, everybody's counting on that one. 27 years. All right. Thank you for correcting the record there. An important correction indeed. Next, we have with us Jule Hall, the Assistant Director of Ambassadors and External Programs at Innocence Project. He brings direct experience and reentry expertise to this conversation and policy expertise as well. And Sara Cohbra, who is the Director of the Second Look Network at the Sentencing Project. And Sara leads a national network of lawyers working on resentencing and Second Look reforms. So we have all of our bases covered, I think. Individuals who are focused on Second Look and implementing the law, those who have been directly impacted and benefited from the law itself, those who have policy expertise, and those who are experts in implementing and litigating law as well. And so we'll spend some time toward the end of our conversation fielding questions from the audience, but right now, why don't we have everybody up on stage and we'll start the conversation. All right. So I think your microphones are already on. It should all be on. Okay, good. All right, great, perfect. Everybody's ready to go. So why don't we start off by defining second look and talking a little bit about why it matters. And so for this, I want to actually turn to Judge Gleeson and to Sara. So maybe you could talk to us a little bit about what second look sentencing actually is, how it's distinct from good time credit, parole, clemency, innocence protection claims, these other kind of appeals, conviction integrity review, these other kind of avenues for revisiting sentences. So why don't we start with you, Judge Gleeson, and we'll turn to Sara after that.
Sure. Thank you. Thank you for having us. I had a relationship with Ken Thompson because he tried cases in my courtroom, both as a prosecutor and before he became district attorney. So I want to speak to Lushan later because I had a deep affection for her husband, and thank you for having us. Second look distinguishes itself from other ways in which folks can get relief from a sentence. It's chief among its characteristics is it's not a challenge to the legality of a conviction or the legality of a sentence, the way direct appeals and habeas corpus petitions and sometimes conviction review unit cases are. It's my project at Debevoise, of which Kevin is one of our clients, is very much a guilty project. They're guilty, but anybody who thinks that someone's guilty of a crime can't receive an unjust sentence, that's grossly excessive, hasn't been hanging around federal court for the last 30 years. And anybody who thinks someone who fits that description can't turn themselves, even in a federal prison, which is not the most, they don't do any correcting in federal prisons for the most part. But anybody who thinks someone like that can't turn themselves around into an admirable human being has no idea what people are capable of. It's not like clemency, even though clemency shortens the sentence. It's not like parole because it's judicial branch. It's not a power vested in the chief executive, as is the case with clemency, or in some opaque parole commission, as is the case in many places, used to be the case federally. It's rather vested. The idea is to take literally a second look at a previously imposed sentence in the same courtroom, if not before the same judge, because time passes, but in the same courtroom in which the person was sentenced. Thank goodness Sarah's going next, because I'm sure I left something out and got something wrong, and you'll help me out, please.
Is this on?
Yep.
Yes. Thank you very much for having us. I'm really pleased to be here. And Judge Gleeson, you actually answered pretty much everything that I was going to say. I will just distinguish a little bit between, so what Judge Gleeson is going to talk about more during this presentation is the federal system and the First Step Act and compassionate release. That's his focus. My focus is more on second look laws that are passed by states. So I'm more familiar with the variety of second look laws that that various states have passed. And what those laws look like is they are laws that recognize that, in the past, our efforts to impose very harsh sentences now there's recognition through research and experience that very harsh sentences do not advance community safety. They don't take into consideration the fact that people can change. And the way that they are framed in states is they are usually directed at particular categories of people. So we started with second look opportunities for people who were youthful, who were under the age of 18, or who were emerging adults, so between the ages of 18 and 25, with some variation in states. when the offense for which they were convicted occurred. And that was a reflection of brain science, right? The fact that young people, their brains are not fully developed, the effect of their hormones and their sort of risk, the fact that they take risks more than other people lead them to engage in criminal behavior in a way that people don't as they age. But there are also other kinds of second look laws that address other different kinds of people, including domestic violence survivors, including veterans, and it just depends on what the state finds important, the category that the state finds important.
Great, thank you. Thank you for that, and thank you for kind of helping clarify the kind of various avenues, both at the federal level and at the state level. I'm curious, maybe if Sara or Judge Gleeson, or really anyone on the panel could talk about this, fill this next question. Why is Second Look a racial justice issue? And how do you see it responding kind of to the extreme sentences, the trial penalty, the issues of like aging behind bars? But I think I'm mostly concerned with that first question, like why is Second Look a racial justice issue?
I could jump in quickly.
Good, because that falls squarely in the don't get me started category. So,
Yeah,
please.
it's a very important question. First and foremost, thank you for allowing me to be here. I represent the Innocence Project, where close to 67% of our clients are people of color. We are strongly in belief that if a person innocent shouldn't be in prison, but to answer the racial dynamic, the numbers show, the evidence shows that people are disproportionately people of color who are impacted by law enforcement, policing in certain communities, receiving harder sentences, and in the case of the work that I'm doing, wrongfully convicted and incarcerated for crimes.
And, I'm sorry.
No, go ahead.
I'll try to distill the don't get me started part. Kevin Haynes was convicted of the most onerous mandatory consecutive sentencing regime in the federal system, which is saying something because federal system has some pretty serious mandatory penalties. It was so onerous, it was prospectively repealed, pulled back by the first Trump administration. But here's the important point. The Sentencing Commission on 3 separate occasions, 2004, 2011, 2018, reported, and this has never been disputed by the Department of Justice, it's not an automatic onerous sentencing, mandatory sentencing provision. It has to be invoked by the prosecutor. And the commission reported that it was invoked in a severely racially discriminatory, disproportionate way against black men by the Department of Justice. So writ large, as my colleague has already mentioned, and when it comes to case-by-case invocation of harsh sentencing provisions, I mean, Second Look is not just a racial justice issue. It transcends that, but it's also a racial justice issue because race-based inequalities are just baked into our system.
And just to add on to that, the research also shows that a lot of what impacts the length of somebody's sentence is criminal history. So for black and brown young men, usually, who start by being targeted when they're in school. You know, we all know about the school to prison pipeline. And are targeted early, are adultified, and acquire a criminal history that is then used to enhance sentences that are imposed later. And for that reason, people of color are serving far longer sentences across the board than white people.
So we clearly have kind of racism baked into the criminal legal system. It's clearly part of the conversation here tonight when we think about second look. One other question I want to ask before we kind of start to talk a little bit about Kevin's particular case and hear from him is it seems like second look has gained more prominence in recent years. It's become more of a focus of policymakers and something that's become, I think, more prominent on the minds of folks both in the criminal legal system and outside of it in terms of reforms. And I guess I'm curious, like, what you attribute that growing popularity around second look to. Maybe I'll ask Sara if you have a sense, and maybe you can share based on your own experiences.
Sure. So I will say that I think the movement relies on momentum, right? And I think that there has been a recognition that other forms of relief, allowing people to come home before the end of their sentence, parole, primarily parole, that parole is often an ineffective method of getting people home. People repeatedly go before parole boards. For the most part, incarcerated folks are not entitled to have legal representation before parole boards, and often aren't provided with all of the information, even in their own prison records, to be able to use to advocate on their own behalf. And I think that there has been recognition that we need to have other alternatives, other methods, even outside executive power, right? Outside of the clemency or commutation or pardon realm as well. And that having opportunities for people to go back before courts and benefit from some due process provisions, sometimes get representation by counsel, although not every Second Look Act provides for that. But that was sort of the beginning of how Second Look got started. Mm-hmm. But then since then, there has been, growing evidence that people who have served lengthy periods of time, have been released pursuant to Second Look policies, have done very well in the community, right? The recidivism rate for people who are released on pursuant to Second Look is very low. And so I think that that's recognized from state to state, and it's contagious.
Great. Thank you, Sara. So I think we have a pretty good sense of what Second Look is and have defined it, I think, pretty well. Next, I'm going to, I think, dig into an actual case, and that's Mr. Haynes' case. Before I do that, I'm going to ask Judge Gleeson just to briefly explain to us and help us understand what the Holloway Project is, by way of introduction to Kevin's case, and then Kevin, I want to come to you and ask you about your experience.
Sure. When I was a brand new judge, 1995, I got assigned the case U.S. versus Francois Holloway. He had a chop shop. He and an accomplice stole 3 cars at gunpoint in a 24-hour period. And Francois Holloway was offered a plea bargain pursuant to which he would have served 9 years. He would have gotten about 11. With good time, he would have served 9. But he was charged with 3 of these so-called 924C, that onerous, mandatory, consecutive statute I alluded to before. It's a firearm statute. And because he chose to go to trial, he actually had a separate legal issue with respect to the carjacking statute that actually went all the way to the Supreme Court, which he lost. But because he went to trial, he had to, the government obviously would have been fine for him to be back on the street in 9 years. Because he had the temerity to go to trial, and I commend to you Professor Barco's chapter on Bordenkircher. He received a trial penalty I had to impose, 57 years. So basically, he paid for the right enshrined in the Sixth Amendment, the right to go to trial. He paid for that right with almost 50 years of his life. And that sentence rankled me for 2 decades. They keep writing you. When you're a judge, just because their appeals and their habeas petitions are all done, they don't stop writing to you. And he wrote to me 20 years into his sentence. And by then, I knew the racially discriminatory invocation data that the commission had reported. And I wrote to the U.S. Attorney. Loretta Lynch later became our Attorney General. And I wrote it all out. And I said, geez, come on, have a heart. You know, there's no defect in this, but could you vacate a couple of his 924C, those firearm convictions? And you could have knocked me over with a feather when she said yes. And it allowed me to give Francois Holloway back the rest of his life. And that made me, that's how I got to know Kevin. You know, word travels fast in the Bureau of Prisons, and pretty much everybody serving these stacked 924Cs in the Bureau of Prisons wrote to me, not to do, I wasn't their judge, like just to say thanks for pointing out the situation that we're in. And I kept the letters, hundreds of letters. And 2 years later, I leave the bench. That summer is that summer's installment of what later on became George Floyd, successive shootings of black men by cops in the summer of 2016. And my firm leadership said, what can we do to on a concrete basis, address a racial inequity in criminal justice? And I said, we got a Holloway Project. I had all the clients. I had their letters. And we started the Holloway Project. It's had the pendulum's been swinging back and forth. We started out with no law to help us. Then in 2018, we got a law that helped us. And the law kind of went sideways, and I went on the commission, and the commission fixed it, and now the Supreme Court's going to weigh in. But we started the Holloway Project to rectify, send people whose families love them and whose communities need them home.
Thank you,
And
Judge.
that's what Kevin.
Yeah, thank you,
That's how I
Judge.
met Kevin.
It's truly a phenomenal thing. And so with that, Kevin, I'm wondering if you could walk us through your experience before you came into contact with the Holloway Project, and maybe start the story at the beginning, and share with us kind of how you ended up in this awful situation in the first place, incarcerated, and talk a little bit about that.
Well, first and foremost, thanks for having me. Where I came from, I never thought I'd see the day where I'd be sitting before all of y'all. So thanks for having me. This is really overwhelming, but thank you. Anyway, typical kid from Brooklyn, Bed-Stuy. So, got with some people, things was hard times in the family. So we robbed some banks, me and this guy, and this was in the early 90s. And, by 1993, my co-defendant, he got caught, and he ratted me out and cooperated with the government, as y'all like to say. But yeah, he ratted me out, and they brought me in. I was indicted. I received a 5-count indictment. It was 1 count of conspiracy, 3 counts of bank robbery, and 1 count of 924C, 18 U.S.C. 924C. I went to trial. I seen they really didn't have nothing on me, so I went to trial.
You left out the part where you were given a plea deadline. Then when you didn't plead, they went back in the grand jury and added 50 more years to your sentence.
Very important.
Well, I did receive a plea, but I didn't take the plea. So my plea was 8 years. It was actually 8 years. I would have did, 6?
Yeah.
6 off the 8 years. So I said, no, I'm going to trial. So when I went to trial, the prosecutor said, if you go to trial, write to the judge. I'm going to give you 2 924Cs. I didn't think they can do that. And they did it. So I went on the trial, and I was sentenced, lost trial, it went from a 5-count indictment to an 8-count indictment with 219, 24Cs on it. So I went to trial, lost that trial, and I received a 558-month sentence, which is 46 and a half years. Of the 46 and a half years, I did 27 of them. So that's that. You have another question?
That definitely answers that question. I'm curious, as you're doing all that time, did you ever have any hope of getting out any earlier than that 47 or so years?
Well, one thing you're going to realize about most of when you first come in the system, right? A young lady was talking about the DC, talking about doing DC cases. Mm-hmm. When you first come in the system, you're angry, right? So when you come in the system, you're not going to do right your first 5 or 6 years, because you can't give someone like a life sentence and then tell them, now go be good for the rest of this time. You just can't. It's just not going to happen, especially if they haven't murdered nobody or harmed anyone. In my case, no one really got harmed. So in most cases, no one really got harmed. You're just being punished for going to trial. So while I was in there, I just refused to succumb to, like, I was better than that. Regardless, I was better than that. So I refused to succumb to, like, the grudge and the evil and the hatred and the wickedness that was in there. So I read a lot of books, spent most of my time at the law library, watched the news, and always watched the news, stayed abreast of current events. And in that type of environment, it's hard because, a lot of guys is, it's not women there. So, you don't touch them. So everybody just want to watch TNA all day. So a few times I even had to fight for the TV because I'm watching the news. I just want to stay abreast what's happening, watch different educational programs. So that was even a fight and a struggle in there. But you have certain like-minded individuals, so that's with you. So it's kind of like a body of us. So that's how you stay. I made it.
Can I give a little bit more context to that?
Please.
So I served 22 years in prison. Long story. I got a great education with the Barred Prison Initiative. But here are certain things that I understood when I first went in. It's the old traditional structure and agency tension where an individual is in there, they're angry, but the structure does not do anything for them to allow them to deal with that anger, their mental health issues, or so many things. When I was incarcerated in 1993, let's put this in a larger context, college programs were stripped from prison. 95. And I went into prison and I had to make a choice of just going to law library to pro se litigate my case because I felt that I had issues with my case. But I saw how when the college programs were stripped out of prison, people got into all types of devilishment because they didn't have anything better to do with themselves. Idleness, my grandmother used to always say to this, idleness is the devil's playground. However, just like the brother said, I went to the law library, I got with like-minded people. I want to say that there are people in prison who want to do better. Right. And even though structures aren't allowing them to, they are working really hard to do so. I was fortunate, like I said, to get into a college program, and that just shifted the whole paradigm. I remember literally being in the prison yard, people, like you said, are watching TV and doing nothing, to now people are in the prison yard studying for classes and preparing for tests. So I really feel like, there are ways in which, and I want to give credit to the college and prison thing has spread a lot in prison now. So a lot of people are like, hey, I want to do something better with myself, and there are avenues for me to do so. But if we think about this time frame of mass incarceration, tough on crime, leading from whether you start at the 60s, well into the 80s, into the 90s, there was this retributive, punitive aspect of prison, lock them up, throw away the key, they don't deserve anything, and that is not how you make whole individuals or turn a person around from doing wrong.
I'd like to expound on that. In
Yeah, please.
1995, Bill Clinton passed a crime bill. And in this crime bill, he took all the Pell Grants out of the prisons. Well, I don't know how it was in the state, but in the feds, he took all the Pell Grants out of the prisons. So if you want to go to college or any type of school, you had to pay for it yourself. So this is another reason why recidivism is high, because when I was in it, that's how it was. So I ended up opening up a little store, and that was my little hustle. When I had little things, I had to sell ink pens, whatever I can do. And I paid for my education. I went to Blackstone Law, and I paid for my education. But I shouldn't have had to pay for my education being in there. But see, here's the danger. I'm out now. What if I didn't do something to reform myself? What if there was, even if I tried and there just wasn't nothing there? And these people coming out here with no education, with nothing. You understand? They're like, I came home and the majority of my people was dead. You don't even have an education. So thank God for my sister, my brother-in-law, and other they sitting right there. Right there. But thank God for them, as well as Judge Gleeson and Robin. But you know, if I didn't take the time out to do that for myself, and it was a struggle, and it shouldn't just be that hard. And I was like, who takes the education out to prison unless you have never had no intention of ever letting anybody out?
But 85% of the people incarcerated will be released one day.
Right.
Yeah.
Right.
So people will get out. So it's important, I think we're going to talk about this, to think about that paradigm of how they're released and what happens and how we could make sure that they have a pathway to, the word is, I don't like these words of recidivism, and find a way to be in community that supports the community's safety as well as their own well-being. I think that is very important.
Yeah, no, 100%. And I think, and I think part of this conversation, when we think about second look, you mentioned it, Kevin mentioned it as well, is this kind of attitude of just lock them up, throw away the key, and a failure to recognize, or even an intentional effort to basically treat people as though they're just like throwaway people.
Yeah.
And we don't need to be concerned with anything about their well-being, about their education, about their health, about all the things that we know make people thrive and survive and live positive, productive lives. And so I think part of what you're pointing to is all these sorts of challenges. And I guess it gets me back to another question, Kevin. So how did you actually come in contact with the Holloway Project, and how did that process unfold?
Still going to the law library doing my thing. A guy named Ian Owens has started this thing called Mercy Me 924C. So he put up signs and told everybody, he put signs on all the units in the prison, told everybody come down to the law library, told everybody come down to the law library. And that, excuse me, I don't know if you heard me. Anyways, a guy named Ian Owens, when I was in Pollock, Louisiana, I was still going to the law library and stuff. He put up signs in everybody's unit and told them, come on down to the law library. And he had started this website and this Facebook page called Mercy Me 924C. It's still up. And we all went down there. It was the meeting of the minds. So the guys who knew more about the law and stuff like that, it was like maybe 7 of us. Overall, it was like 30, but it was like 7 of us. He says, we writing letters, we writing Congressman, Keith Ellis, and everybody, right? Then Judge Gleeson did what he did with the Holloway, so we wrote Judge Gleeson. We told him, thank you. We appreciate everything you did, and that was very big, because he highlighted, what's happening with the 924C. So, okay, we sent them a card and a picture of us, and in the card, we all put our name and the time we were serving in there, right? So he's on the bench. So when he leaves, so everything's done with. So when he leaves, he's packing up, and he found our card in the picture. And he contacted Holland Protest, who was Holloway's lawyer, and told Holland Protest to contact them guys down in Louisiana, tell them to give me 20 of their names, and I'll see what I can do by way of representing them in the case, right? So that's what he did. But I mean, that was big. Who does that? I mean, so the rest is history.
Yeah. Judge Gleeson, I don't know if you want to fill in anything that was left out there.
No, I still have the card that it just said, "You're appreciated," and then it was like Kevin Haynes, 46 and a half years. And there were some guys who signed that card who one of them had more than 1,000 years, a lot with hundreds of years. To give you a feel for the significance of this the need for a second look, we've gotten 73, Kevin's one of 73 reductions we've gotten. The average reduction is 40 years.
Wow. Jeez.
So it's like, we're not talking about nibbling around the edges of sentences. We're talking about rectifying egregious injustices.
And so tell us, like, walk us a little bit through the process. Like, when you started working on Kevin's case, what sorts of things did you think what does the law require the court to focus on? What did you think the court would focus on? And then, Kevin, I want to ask you something similar.
It's a great question. The statute, as relevant here, is actually pretty simple. It says, finality rules the day in federal sentencing, and you can win your appeal or get a habeas. There's some narrow exceptions to it. And this one says you can reduce a sentence based on extraordinary and compelling reasons. And when we were first able in 2018 to go to court, thanks to the First Step Act, we thought, what could be more extraordinary and compelling than someone doing essentially a life sentence pursuant to a racially discriminatory invoked statute, who's turned himself around in prison, and is only doing it because he went to trial. So we went to court, and then we learned, to answer your question, the things that were important to judges were not. We screened the people that we represented, because you have to look at offense conduct. You have to look at, Kevin was in for more than a quarter century. How did he comport himself in jail? The principles associated with the cognitive development of youthful offenders were very important, because in the interim, all that social science and neuroscience developed, so they were a little less blameworthy than maybe the judges thought they were when they were forced to impose these sentences. So, the idea of a second look is, he already got sentenced for what he did. Who's he now? And release plans, if he does get out, where's he going to go? Where is he going to live? What's he going to do? So we very much encourage judges to bring our clients before them. Some of these judges were like me. They were rankled. They were just irritated about these sentences for decades, and they were hungry to rectify them. Others needed to see the human being that this person who'd been sentenced 2 decades ago is today. And and that makes the human element of it is so important. And truth be told, an insufficient percentage of the judges actually want to do that, want to put the marshal service to the trouble of bringing someone in to face the judge. That's a bit of a problem, but those who did it, the humanity of it resonated with them.
And Kevin, maybe you could tell us a little bit about what you were hoping the court would focus on in your particular case.
Releasing me. No. Well, basically, you have to go into somewhat of the history of the 924C, right? Because it was implemented in '68 behind the murders of Martin Luther King and Robert Kennedy, right? From 1968 to 1993, for 25 years, they wasn't stacking. They tried it, but they wasn't stacking, right? It wasn't until 1993 when they came out with a case called Dills versus United States. Now, it was 4 in dissent, 5 in favor. The argument was, the argument was that the statute was ambiguous.
And just so they're not like you, they're not steeped in this.
Okay.
This is the question whether you can get those mandatory stacked 20, at the time 20, later 25-year sentences in the same case as your first conviction.
Right. So
Okay. Sorry. Go ahead.
No, that's good. That's good. Because how it goes is when you receive Puffin Rogers, who was the congressman who implemented this in 1968, how they had it was, and they explained it. They said this is so the robber or whoever the criminal is leaves his gun at home. So if he tried and he convicted the first time, he get 5 years. If he get out and get tried and convicted again, he get 20. So it'd be 25 years altogether. If he get out and do it again, it'd be 45 years. So for 25 years, it ran that way until 1993 with Dills versus United States. And when that happened, they made you a career offender all on one indictment. They put, oh, you robbed 3 banks, we're gonna give you 5, 20, 20. Each count would be, more and more and more. So in the Dills case, the guy got 105 years. It was argued that it was never meant to be applied this way. The proof of that is what the congressional intent. However, they said it was still ambiguous. Scalia and the crew. So what they ended up doing was, Scalia, Thomas, and the rest of the crew.
It's nice to know I'm not the only one here who has a "don't get me started" topic.
These are justices. But Sandra Day O'Connor, who was, God bless her, retired Supreme Court, she did an outstanding dissent. And she says, if y'all saying y'all don't know and it's ambiguous, it should fall under the rule of leniency. Rule of leniency is something under the 8th Amendment. If this is a federal state statute that's ambiguous, then it automatically goes in favor of the defendant. They said no, and then they said when Congress expressly intent, whatever it is, regarding how the 924C apply, they'll fix it. But
The question was what you wanted Judge Deary to
This I'll
focus
tell you.
on. Yeah,
I
we
want him-
getting to the answer to that sooner?
but
or later?
I just want to get into the history of the 924C. But I basically wanted pretty much to be released. The injustice, the First Step Act, the aspect of the First Step Act, and how it to be, for it to be ruled in my favor. Yeah. And as well as my conduct and stuff that I was in prison. I mean, I wasn't too much of a bad guy.
Yeah.
I mean, I'm not an angel. Hey, if you listen, if y'all think I'm gonna get up here and tell y'all I was an angel the whole time I didn't kill nobody. But if y'all think,
Listen, I'm your lawyer. I'm going to
if y'all think, I am not an angel.
Professor Southerland to yes or no.
So one thing, Sarah, I want to ask you a question. Just thinking about like the state second look act, like landscape, in terms of considerations that judges have in that space. Are they similar or different from the federal First Step Act? Like what's the dynamic look like there?
I think judges in state courts are interested in the same things as judges in federal courts. In the laws, the second look laws have different provisions depending on what state they're in about what the judge has to consider in making decisions. And for the most part, it includes the same kind of issues, right? And it includes conduct during incarceration, sometimes it includes the nature of the offense, which is problematic for a lot of reasons, but it often also includes role in the offense, so not just what the offense was, but were there multiple people involved, and what was the role of the particular person applying for second look. Mental health treatment that somebody has gotten, work history, a lot of statutes now are also providing for the judge to consider information, the sort of circumstances under which the person was involved in the act that resulted in the conviction. So that could, that is, whether a person is experiencing a lot of trauma at the particular time. So there's, a mitigation story from prior to incarceration that's important to, in a lot of these cases. And, one of the things that is the most, that really limits the ability of second look laws to do what they're supposed to do is when there are major carve-outs for certain groups of people. So they, a statute applies to, gives the opportunity to anybody who was under the age of 25 at the time of the offense to apply for second look, except people who were convicted of murder, or people who were convicted of killing a police officer, or people who were convicted of some sort of sexual violence. So there are, many people who have been serving really lengthy sentences for serious crimes, but who have completely rehabilitated. Who are doing very well, who are mentoring other people in prison, who are supporting their families through work that they do in prison, who are raising their kids by being in phone contact all the time. And those people are excluded because of the way that some of the laws are written.
Can I just clarify one thing, a question really? So my understanding is that a person who is applying for this relief doesn't have to, if they are fighting a wrongful conviction, doesn't have to, like certain other things like parole, show remorse for the crime or things like that.
So second look is really designed for people who are not saying that they are innocent, that they were wrongfully convicted. There are circumstances when I would say that, especially when there are offenses in which multiple people were involved and the relative culpability of each was not considered at the time of the trial, or there was a trial penalty where perhaps the people who were more culpable pled, right, entered a plea and then testified against a person who was less culpable, right? And so that person ends up serving a much longer sentence. Second look law can be effective in reducing sentences for people under those circumstances. It's not really geared for people who were wrongfully convicted.
Yeah, so they're never placed in that bind where some people go before the parole board. They believe in and have professed their innocence, but they're forced to essentially admit the crime, and that bind doesn't exist. These are guilty projects.
So I want to actually circle back to something that we talked about a little bit earlier. Understanding that second look does take stock of and take account of all the things that have happened in the past, but it is very much like a forward-looking enterprise, thinking about who this person is today and what their life is going to be like going forward. And I guess that brings me to a question around rehabilitation and growth while incarcerated, and what that actually looks like, and what true rehabilitation and growth looks like behind bars, beyond like the formal credentials and certificates and degrees and things like that. I'm wondering, Jule, maybe if you can share what that means to you, given your own experiences of incarceration, and what rehabilitation actually takes, what it requires, what it demands, and what that looks like on the other side.
Yeah, I could talk about that. I think language is really interesting to me, and rehabilitation implies that there was something that was inherently wrong with a person that needed to change, and I really stand by this idea from being in prison that there are talented, capable people in prison who, were caught up in things, and we know that there's structural factors of poverty and neighborhood that influence the ways in which people are incarcerated. But for me, I like to use the word transformational, that people see things differently and engage things differently. I want to be very clear. I think while I was in prison, people were struggling with clarity about what they needed to do to get out. So I think when these laws are implemented, there needs to be a degree of clarity, even if it's about a credential or how a person can pursue a pathway to either get some relief from a extensive sentence or be released by parole. For me, there was a lot of confusion about what I need to do to get out. But what it looks like, I could tell you what it looks like. What it looks like is the mentorship. I actually learned from a lot of people who had been incarcerated longer than me. Crazy idea when I first saw it, but I remember an older gentleman, it was a younger guy on the tier in which we locked. It's about, I want to say 20 cells on the tier, open gates, and a young guy was playing his radio so loud. And this older gentleman who had been in prison for a while went up to the young guy's cell and said, hey, turn that radio down. Because this guy was well known in the prison, the kid turned his radio down. But I asked him, I was like, old timer, why would you put yourself in a situation to be in conflict with this young guy about his radio? Because there is a perception that we are all here in prison individually and we're not responsible for each other. I started seeing that change while I was in prison. And that's just what the older person told me. He said, listen, I was sentenced to natural life, so I have to live here. And just like anybody in any community, I want to make sure things are going right in the community. So I'm a really talk, he said, the young brother, I'll give him a book. I'm not just telling him don't find a way to pass the time, but the radio was a little loud and the officers would come. So that's what that transformation, I think there's a way in which we can look inside prison and see people who are doing things inside prison. There's NAACP chapters in prison where guys are getting together to have talks. We just had a film, Sing Sing, that was based on the program, the dancing program, Rehabilitation Through the Arts. There's all types of things that guys are, and women, are getting engaged with in prison that makes it a healthy community, if that's a bit ironic. You know, because the idea is that while I'm here, my dignity isn't lost. While I'm here, safety is still a concern. While I'm here, I need to care for other people here so that we all could have a better living experience while incarcerated. So I think that's what it looks like. You have to find those people who are engaged with the community inside prison. But I think, again, I'll just reiterate because it's so important. I saw that when I was in there. If you don't kind of clarify, hey, you need to have some type of college education. You need to work consistently. You know, people will not understand what they need to do, and it's more liable for a person to go astray in that instance and not fall into the category of a transformational, evidence of a transformational experience in prison where they're doing better and don't deserve to be there anymore.
Can I just
please.
add something to that?
Please.
So that, I mean, that's really powerful and really important. And I mean, I had a client who was on death row in California, and he went in, he was arrested and incarcerated. He didn't know how to read. He, you know, he was very angry. He had not had the kind of care he needed as a child. And he, over time, taught himself to read. He started doing, you know, and he was in San Quentin in California, where their programming was really crappy. Yeah. Especially for people who are on death row, because the idea is, why we don't, you know, they're never getting out. But he taught himself to crochet. He then started a program where he taught a lot of other people to crochet. He he started like charity events. Yes. So they did, you know, races or walks on the yard and earned money to donate to various charities. I mean, he was somebody who started with nothing, and with very little help from the prison, developed his own way of coping and of really, I mean, and growing. He got released, so I'm very happy he got released a year ago. But I also want to say that I think that one thing that's really important is that judges who are considering these petitions need to understand what is actually available in the facilities where people are being held. I think for clarity's sake, what is it that people need to do in order to be released? It really should vary depending on what is available to folks. And also to what a particular person's circumstances. So there are people with disabilities. Yes. There are many, many people with disabilities in our prison system. Yep. And many of those people are excluded from a lot of the programming that does exist for a variety of reasons. Either there are educational requirements that somebody needs to have satisfied in order to be admitted to some sort of program, or they have a physical disability that requires them to be housed in a special, like a separate unit that doesn't have access to programming. So I think that there are, I agree with you that it's really important for people to know what they need to do, but I also think it's really important for the decision maker to know what is possible.
Mm-hmm. And just to add to that, in the federal system, there's some programming that you only become eligible for if you're short, if you
2 years before
you get,
you're released.
And we found ourselves, when judges didn't want to give time served, we would say, or didn't want to reduce an 80-year sentence down to something that's reasonable, asking them to reduce it to something that might still be unreasonable, and then we'll come back, because they're always without prejudice, to another one, just so they could become eligible for the programming. Mm-hmm. It's a very complicated system.
Yeah, and it almost seems like most people have to succeed in spite of prison, right? And all the work they're doing is in spite of the prison. And so many of the most effective programs that I've seen or heard about have been programs that have been designed and created by the people who are in the prison themselves. Yeah. Right, which I think speaks a lot to the sort of community that Jule was talking about that folks need to build. Kevin, I'm wondering if you can, you talked a little bit earlier about early on in your term of incarceration, you encountered a lot of real difficult challenges, and you're maybe not as you had a lot of disciplinary tickets and things were not kind of perfect as you want them to be. At some point, things changed for you, and so I'm curious, what was it about your experience, or what was it that kind of led you to change directions somewhat while you were incarcerated?
Well, in 1995, we had a crack riot, and they sent me to Louisiana, and I did
Can I just briefly explain the crack riots?
Okay, go ahead.
The commission eliminated the onerous 100-to-1 ratio, where 100 grams of powder cocaine was equivalent to 1 gram of crack cocaine. But then Congress passed a law basically vetoing the commission. That's the crack riots.
That's correct.
Sorry.
That's good. Thank you.
Yeah,
For clarity.
helping
So,
you out.
1995, we had the crack riots, and they had the guys who shut the jail down, because I was in Lewisburg. It was never about tearing up the jail. It was about seeking justice for the people. So we shut down the unicorns and stuff like that. So allegedly, they said I was one of the leaders on the West End. So
Allegedly.
allegedly. So anyway.
Unicore is the prison industry.
Okay, Unicore is a prison industry where they pay you like 10 or 15 cents an hour to make beds and stools and cups and mattresses and what else they was doing? Mail bags and stuff like that. Army stuff, like the stuff the Army did. That's what. But they only paying like 10, 15 cents an hour. So we shut it down. It was nationwide. The whole Bureau of Prisons shut it down. So after that, they sent me to Terre Haute, Indiana. And when they say in the feds how they have it, if they deem that you're too influential on the East Coast, they'll send you somewhere you don't want to be out Midwest. So I did 10 years in Terre Haute, Indiana. And when I got back, I got to a medium, and I seen my mother. Because I haven't seen my mother. My mother came out there once or twice, but I seen my mother, and when I used to see in Lewisburg, and when she came to the Terre Haute, she's bouncing around. She, my mother was up in age, but she was moving around. And when I came out to see her in Farrington, New Jersey, I was at a medium, hated it there. But she came to see me. So when she came to see me, I didn't see the wheelchair. She was sitting in the chair. And I looked at her, and she was frail. And I was like, damn. So we went out to take pictures. So I'm used to the chub hopping up and walk. So I got up and I walked. And I looked back, and she's barely it, and she's walking. I'm like, so I went back, come on, Mom. So we went and took pictures and stuff like that. And like, my daughter, she was under here. Now she's taller than me. So, because she was like 9 when I left her. And I was like, damn, I've been in jail too long. And so when she's leaving, I never forget, I got a grandson now, my first grandson. He's like 3 years old. And he said, come on, Grandma, they put in a wheelchair. And she in the wheelchair, and my grandson's pushing my mother out in the wheelchair. So I was like, yo, you got to do something to get home, man. So, and that was like the main, before she died, so I got to get home before she died. And that was like the main thing that, like, I have to do something. So I was in Farrington, but how it was in Farrington is if I still had a bunch of years left. And they don't let you go to school down there because it's only for people that has 3 years left because it's a FCI, it's a medium, for medium custody. But eventually I got kicked out of there and went to a USP, so yeah.
But I just want to bring attention to the fact that the system essentially punishes people by sending them far away from their family. That's just something I just wanted to lift up.
Yeah, so that's when I was like, yo, you got to do something, and you got to try to get home before your mother passed away. I'm like, damn.
So we have a few minutes left. I want to open it up to the audience for any questions that folks might have. There's a microphone in the back. If anybody does have a question they want to ask, just feel free to raise your hand, and Courtney will bring the microphone to you. If not, I do have a couple more questions for our panelists as well. So I will keep asking questions, and then we'll see if anybody from the audience is brave enough to ask.
Are we allowed to cold call on people?
I don't think so, but we can try. Okay, all right, yeah, we have a couple questions. All right, so we have one right here and one right there.
Here. Can you pass it to her, and then can you pass it to India?
Oh, thank you so much. I'm just so grateful to be here. I'd like to thank my friend Sean Thomas, the late great Ken Thomas, for all the great work he did in that time and space he was. But I wanted to can you just dig deep into that crack piece? Because I know my community and my family was ravaged by the crack thing. But you said something about the law with the crack and the powder cocaine, the crack cocaine. And then also, I have a brother that did 25 years in jail, and it was just a robbery. So how do we begin to change those laws? And I just had a brother that just came home. He did all his life in jail. When he came out, he had cancer and died. So I don't know what's happening in the prison with some of the brothers that's coming home. But how do we begin to shape, because I thank you for sharing your story. I got part of it. I want to hear more of your story. But how do we begin to shape the system? Because they say the system is broke. It's not broke. It's working the way it's supposed to work. And it has kept our people crippled for years. It is the continuation of the modern day slave trade. So how do we now begin to educate? Are you a judge?
I used to be a judge. Now I'm back among the unwashed.
So now how do we begin, I need you on my side. So how do we begin now to get into these courts, to talk to these judges, to have some seminar about changing how they sentence, our brothers? Because the majority of the prisons are filled with Black and Latino brothers. And my brothers, they spend most of their lives in jail. So how do we begin to to change the laws and shape some of these judges? Because you mentioned something about the judges and how what do they have in front of them when they're making these decisions to sentence some of our brothers to these outrageous numbers?
Well, there's a lot to unpack in your question, but, you know, it's partly judges, it's partly that we live in a world, we live in a system where change that dramatically responds to some prominent event that results in bad effects for people charged with crimes can happen like that, overnight. But, and, you know, over the last 20 years, we've reached like a bilateral consensus. We've over-incarcerated. We need to decarcerate. But change, even a little change that inures to the benefit of defendants is like, even when everybody agrees we need it, it's like turning the Queen Mary around. It's just the part of it, the old folks in the room remember Willie Horton, but anything that can be characterized in a soundbite as soft on crime is radioactive. So that's part of it. Part of it is the legislature. You know, I think, and judges, that's just such a long conversation. Part of it is judges growing up in a regime that was created at a time when the murder rate in New York was literally 8.5 times what it is today. So the crime bill that Kevin mentioned was part of that atmospheric.
Then there's the mandatory minimum.
Yeah, mandatory minimums in 1986 were enacted during the Reagan war on drugs. And then even when there's a recognition that's like, whoa, we've gone too far. That's the hard part, is turning it back. And it's the most, I think, the biggest problem with policy adjustment in our system. I know that's not a satisfactory answer, but it's not a satisfactory situation.
Yeah.
Can I just I have a thing for her as well. You are basically describing how you're impacted by the criminal legal system, and you've never been arrested. I'm not making a blanket claim, but generally, we have to focus on families. Families need to mobilize. Families need to advocate for their loved ones who are incarcerated. There's ways in which you have a story. You know, Brian Stevenson said, get proximate to the issue. You need to talk about, in these types of forums and others, about how mass incarceration, the criminal legal system, impacted you because of your brothers. That's still an impacted person. Even though you yourself were not incarcerated, your family members being incarcerated impacted you. You know, there's one study that says at least half of Americans have a family or a friend who's been incarcerated. We need to mobilize and have our voices heard so that legislators know that we want these second look laws, that we want these reliefs for our families who are incarcerated.
Yeah, that's 100% right. I mean, I think part of what we're fighting here is a cultural and narrative battle around the way in which we think about people who have been accused of, convicted of crimes in this country, and for far too long, like the sentencing numbers don't make any sense at all, right? There's no scientific data that tells us that, 10 years, 5 years, 15 years, 20 years is an appropriate sentence for somebody. There's like not any connection to it. People just picking these numbers out of the sky because they sound good. Quite frankly, like 5, 10, 15, that's just simple math, right? It's not a matter of anybody thinking about what somebody actually needs when they've been caught up in the criminal legal system. So I think part of the conversation what Jule and others are talking about is having more forums like these, pushing legislators, pushing policymakers, pushing people to understand the ways in which the systems harm people, and that we need our loved ones home now, right? And trying to reverse some of these trends that we have been sucked into for far too long in this country.
There's an organization called FAM, which used to stand for Families Against Mandatory Minimums. It's FAMM. It doesn't stand for that anymore, but it is a group that engages family members of people who are affected by the system, people who are incarcerated, to lobby, to train people how to effectively advocate. I highly recommend it. The people who work there are very, they're very zealous advocates, and they provide a lot of training and orientation for folks who want to be involved.
So I think we have time for one more question.
You all already answered it.
Okay, all right. Oh, the person right behind you has a question.
Just one question. Victim impact statements. I know judges obviously take that into account at the initial sentencing. How about in second look? Would you ever look into victim impact statements or the assessments or requests of victims when they look into re-sentencing or taking a second look at sentencing? I guess that's really more for you, Judge, if you want to answer that question.
That's a great question.
Yes, is the answer. And as the lawyer for folks seeking relief, I try to find them. I mean, in a lot of cases, they're hard to locate 27 years later, but I try to find them because way more often than not, they support what we want. Everybody in the wake of a crime, every victim in the wake of a crime feels the way victims do, and that is considered at the original sentencing. But as time goes on, I've spoken to people who were part of, the victim of a bodega robbery 22 years ago, and they're shocked. They're shocked that the person who did it is going to spend the rest of his life in prison. So, yes, the short answer to your question is the victim impact always matters. But in this setting, sometimes it's more favorable for the person seeking relief than it is for the government. Not always, but more often than not.
And I would say that most of the second look statutes around the country in various states include a requirement that the court consider victim impact statements.
Okay. All right. So I think that might be all we have time for tonight. Join me in thanking our phenomenal panel. A great conversation. I want to thank all of you for sharing so much wisdom. We have some refreshments, so please join us for some refreshments and spend some time in fellowship, and we'll see you next time down the road. Thank you again for joining us tonight.
Thank you
and don't forget to sign up for your CLE as well.
Thank you so much for your moderation. That was great.